In 1810, Congress passed a 13th Amendment to the Constitution. It would strip your citizenship for accepting a foreign title of nobility. It passed by a landslide. A dozen states ratified it. Then, decades later, someone found it printed in old law books as if it had already become law, and built a theory that it secretly had. That lawyers, using the title Esquire, had unknowingly disqualified themselves from practicing law. That the entire American legal system has been operating illegally for 200 years. Most people have heard neither half of this story. So let's look at both, what's actually true and what isn't. April 27, 1810. The Senate votes 19-5. 4 days later, the House passes it 87-3, both votes miles past the two-thirds required. Its author, Senator Philip Reed of Maryland. Here's what it said. If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, such person shall cease to be a citizen of the United States. Not a fine, not a criminal charge, your citizenship gone. The country was edging toward war with Britain. Napoleon was handing out titles across Europe like party favors. Congress was nervous about foreign governments buying loyalty through flattery and rank. There's a more colorful theory floating around, too, that this targeted one specific woman, a Baltimore socialite who'd married Napoleon's brother. Real story. But her marriage was annulled 5 years before this amendment even reached the Senate floor. Good color. Not a proven cause. 12 states ratified it. Maryland first, in December 1810. Then Kentucky, Ohio, Delaware, Pennsylvania, New Jersey, Vermont, Tennessee, North Carolina, Georgia, Massachusetts, New Hampshire. 4 states voted it down. Connecticut, New York, Rhode Island, and Virginia, February 1811. Hold on to that one. 3/4 of the states were required. In 1810, that meant 13. By 1812, Louisiana joined the Union. The bar moved to 14. 12 ratifications wasn't enough either way. In 1818, President James Monroe told Congress flatly it hadn't passed, not a modern debunking. The government's own conclusion, 5 years after the last state weighed in. Now here's where the story splits in two. Stay with me, because what happens next is where it gets genuinely strange. In the 1980s, a researcher named David Dodge was going through old law books in a small-town Maine library. He found a bound copy of the Constitution, printed decades after 1810, listing this amendment as the actual, adopted 13th Amendment. He kept digging. He says he found the same thing in an old Virginia law code, and eventually in roughly 18 publications across 10 states. Here's the theory, stated the way believers state it. The amendment really was ratified. It was later quietly removed from the official Constitution. And Esquire, the title lawyers use, counts as one of the forbidden titles of nobility. Every lawyer, every judge using it, has forfeited their citizenship. The legal system, in this telling, has been illegitimate for 2 centuries. That's the claim. Now here's the record. Here's where it actually falls apart. In 1815, a Philadelphia printing house under federal contract published a 5-volume set of U.S. laws. On page 74, they printed the still pending amendment as Article 13 inches, right where it would have gone if it had passed. They weren't trying to fool anyone. In the introduction, on page 9, the editors wrote plainly there'd been some difficulty in ascertaining whether it had actually been adopted and that they were printing it anyway, with this explanation to prevent misconception. The explanation didn't travel. Other printers copied the amendment text out of that volume and left the disclaimer behind. The error got copied and copied again for the next 3 decades. And here's the part that should end the argument outright. Virginia is one of the 4 states that voted this amendment down, February 14, 1811. The exact state whose old law books were cited as proof of a secret ratification is, by its own legislative record, one of the states that rejected it. What about Esquire? The amendment targeted foreign hereditary honors, The kind a king or emperor grants, with real legal rank attached. Esquire isn't that. Centuries of ordinary professional use, granted by no government, foreign or otherwise. This hasn't just failed informally, it's failed in court, repeatedly. In 2005, a federal court in Arizona rejected it directly. An old, erroneous printing, the court said, is not the 13th Amendment. Courts in Alabama and Wisconsin rejected the same argument in separate cases. The U.S. Supreme Court itself referred to this amendment as unadopted, in passing, almost as a footnote, in 3 separate rulings across the 20th century, decades before this theory ever existed. One more thing, and it's genuinely strange. This wasn't the only failed amendment competing for the number 13. 51 years later, in 1861, Congress passed a completely different amendment, one that would have made slavery permanent instead of striking at foreign titles. If ratified, it would have become the 13th Amendment too, for the same reason. The last amendment actually added to the Constitution was still the 12th. That amendment failed too. The seat stayed empty until December 1865, when the real 13th Amendment finally took the number, abolishing slavery, the opposite of both of its failed predecessors. The Titles of Nobility Amendment is real. It came closer to ratification than almost anyone realizes. And the mystery of why it shows up in old law books as adopted has a real answer. A documented printing error with its own forgotten disclaimer traceable to one 1815 volume. It was never secretly ratified. It was never quietly erased. It just didn't get the votes, and one printer's shortcut turned a footnote into a 200-year game of telephone. What's actually true and what isn't? Now you know both. If you want the next hidden clause behind the laws that shape this country, subscribe. There's a lot more where this came from.